So we have heard from Laura on why so-called gender identity is absurd on its face and not real in any real-world material sense. From Maureen on, in particular, why the Declaration is so important for naming the problem of male violence against women and preventing it. And from Eugenia on the principles outlined in the Declaration. I want to argue now that any lawmaker or policymaker who is either examining an existing law on gender identity or considering a proposed law on gender identity ought to look specifically at how the law is or is not compatible with each article of the Declaration. To do this, I will take as an example two bills that are currently pending before the United States Congress. One is the so-called Equality Act, which has been pending before the US Congress for several years. The other is the Protection of Women and Girls in Sports Act, which was introduced before the United States Senate last week. My hope is that by examining each of these bills through the specific lens of the Declaration, we can gain a clearer understanding of how both advocates and lawmakers can evaluate laws and legislation specifically with a view toward protecting the rights, privacy, and safety of women and girls. If there's time, I will then briefly touch on two legal matters, both concerning women's sports, that are making their way through the United States federal judiciary. I want to say one more thing, though, by way of introduction. At the current time, most of the conversation about so-called gender identity in the US concerns athletics and whether men who claim to be women ought to be able to compete in women's sports. This is an extremely important topic and one that must be addressed. But it's equally important to understand that the conversation around women's sports is not just about sports. It's fundamentally about whether men can actually be women and whether women and girls are permitted to exist as a category worthy of legal protection. The Declaration is fundamentally about protecting the rights, privacy, and safety of women and girls. That is, female human beings. Athletics is an extremely important component of that. First, the Equality Act. The title makes it sound like good progressive policy. It is not. Fundamentally, it would add so-called gender identity to the list of protected categories in US civil rights law while not doing anything to protect women and girls as a discrete legal category. I would argue that it is, therefore, in its current form, inconsistent with the Declaration. But in order to arrive at that conclusion, we would have to examine the bill through the lens of the Declaration, article by article. Now, we don't have time to do that thoroughly here, but I would like to take this time to at least see how the Equality Act is incompatible with at least Article 1 of the Declaration, and then take a cursory glimpse at how it might or might not be compatible with the other articles. Article 1 of the Declaration states, as Eugenia told us, states should maintain the centrality of the category of sex, not gender identity, in relation to women and girls' right to be free from discrimination. By enshrining gender identity among the list of protected categories in civil rights law, and by failing to protect women and girls' right to be free from discrimination, the Equality Act is inconsistent with this provision of the Declaration. The Equality Act maintains the Equality Act does maintain the category of sex, but it does not maintain the centrality of this category. Subpart A of Article 1 defines discrimination against women to mean any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of marital status, on a basis of equality of men and women of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. The current version of the Equality Act contains no such definition. Subpart B of Article 1 states that states should include the retention in law, policies, and practice of the category of woman to mean adult human female, whose sexual orientation, and the category of lesbian to mean an adult human female whose sexual orientation is toward other adult human females, and the category of mother to mean a female parent, and the exclusion of men who claim to have a female gender identity from these categories. The current version of the Equality Act fails to do this. Subpart C of Article 1 states that states should condemn discrimination against women in all its forms, agree to pursue by appropriate means and without delay a policy of eliminating discrimination against women. The current version of the Equality Act fails in this regard as well. Subpart D of Article 1 states that states should ensure that the words woman, the words woman and girl, and the terms traditionally used to refer to women's body parts and bodily functions on the basis of sex continue to be those used in constitutional acts, legislation, in the provision of services, and in policy documents when referring to persons of the female sex. The meaning of the word woman shall not be changed to include men. The current version of the Equality Act does not define the word woman at all. As for the other articles of the Declaration and how the Equality Act stands up, Article 2 of the Declaration addresses the protection of the status of motherhood as exclusively female. The Equality Act does address discrimination on the basis of pregnancy, but it does not preserve pregnancy or motherhood as exclusively female. Article 3 of the Declaration addresses the rights of women and girls to physical and reproductive integrity. Some may argue that reproductive integrity is not the purpose of the Equality Act, the purpose of which is to address discrimination. We might argue, however, consistent with the Declaration, that any violation of the rights of women and girls to reproductive integrity itself constitutes discrimination. Article 4 of the Declaration reaffirms women's rights to freedom of opinion and freedom of expression. Of course, we in the United States have our First Amendment, and nothing in the Equality Act attempts to threaten that. However, I will just briefly note that there is a case currently making its way through the federal courts called Meriwether versus Shawnee State University, where a professor, who is male, was disciplined by a public university for refusing to use opposite-sex pronouns and titles when addressing students. I realize this is slightly off topic from the Equality Act, but it's worth noting that the United States federal judiciary is currently considering the lawfulness of coerced use of particular titles and pronouns by public institutions. Article 5 of the Declaration reaffirms women's right to peaceful assembly and association. The Equality Act is, of course, a direct threat to this by requiring businesses and public institutions to include men in women's spaces. Article 6 of the Declaration reaffirms women's right to political participation on the basis of sex. But by including gender identity along with sex in the list of protected categories, the Equality Act is in obvious and direct conflict with this article. Article 7 reaffirms women's rights to the same opportunities as men to participate actively in sports and physical education. The issue of sports is a complicated one here in the US because our Title IX regulations allow for the maintenance of sex segregation in sports and education. As I'll talk about later, this particular matter is currently being litigated in the federal courts and was recently introduced by federal legislation, as I will discuss in greater detail. Article 8 reaffirms the need for the elimination of violence against women. To a certain extent, the United States has this in the form of the Violence Against Women Act, which was initially enacted in 1994. Nothing on the face of the Equality Act threatens this. However, it is worth noting that the Violence Against Women Act now includes gender identity as a protected category, which is inconsistent, of course, with the principles outlined in the Declaration. And as Eugenia powerfully told us, Article 9 reaffirms the need for the protection of the rights of the child. This article addresses medical interventions aimed at so-called gender reassignment in children. The current version of the Equality Act does not address this topic, but we know that children in the United States are currently being told in schools and throughout medical institutions that if they are confused, that they might be born in the wrong body and that their so-called gender identity must be affirmed. Arguably, therefore, by not addressing this fact, the Equality Act is incompatible with this article of the Declaration as well. For these reasons, the Women's Human Rights Campaign USA chapter thinks that the proposed Equality Act as written is incompatible with the Declaration and therefore must either be rejected or revised to eliminate gender identity from its provisions. There's another bill currently pending before the US Congress called the Protection of Women and Girls in Sports Act. I would like to read the bill in its entirety because it's extremely short and elegant in its simplicity. The law that it would amend, if enacted, is, of course, our Title IX of the US Civil Rights Act, which prohibits discrimination on the basis of sex in the educational arena. The new bill reads, quite simply, "Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. This act may be cited as the Protection of Women and Girls in Sports Act of 2020. Quote, it shall be a violation for a recipient of federal funds who operates, sponsors, or facilitates athletic programs or activities to permit a person whose sex is male to participate in an athletic program or activity that is designed for women and girls. For purposes of this subsection, sex shall be recognized based solely on a person's reproductive biology and genetics at birth." That's it. As addressed above, Article 7 of the Declaration reaffirms women's rights to the same opportunities as men to participate actively in sports and physical education. As such, the Women's Human Rights Campaign USA believes that this bill is entirely compatible with the Declaration. Now briefly, to touch on two cases that are pending before the US judiciary at this time. One is the case of Soul versus CIAC in federal court in Connecticut. In this case, 4 extremely brave young women have sued their school districts and their state athletic association, arguing that the policy of allowing boys to compete in girls' sports discriminates against girls in violation of Title IX. That matter is pending before the lower court, but in the meantime, during a hearing in the case, the federal judge overseeing the matter ordered one of the girls' attorneys not to refer to male athletes as male. The attorney has appealed, and that appeal is pending as well. The Declaration is rightfully unyielding in its insistence that the words woman and girl mean human female. Language matters. Therefore, any legal ruling that states otherwise should be considered to be incompatible with the Declaration. Another case currently pending is the case of Hecox versus Little in federal court in Idaho. In this case, the state of Idaho enacted a law to protect women and girls in athletics called the Fairness for Women in Sports Act. Incidentally, that law had been introduced by a female lawmaker who was herself an athlete and a basketball coach whose life was transformed by the enactment of Title IX in 1972. She saw what was happening to women's sports, and she took action. Expectedly, a young man sued the state, arguing that he had the right to compete in women's sports because of his so-called gender identity as female. That matter is pending in court as well. Earlier this month, the federal court overseeing the matter issued what is called a preliminary injunction, meaning that the law cannot take effect unless the court ultimately rules in its favor. But again, the Declaration is clear. Article 7 reaffirms women's rights to the same opportunities as men to participate actively in sports and physical education. This means that women have a right to compete with and against women. In other words, adult human females. Any legal ruling that is counter to this is incompatible with the Declaration. My purpose here today has been to encourage all of us, including attorneys, advocates, lawmakers, and policymakers, to be continually examining laws and policies existing and proposed for their compatibility or non-compatibility with the specific articles and provisions of the Declaration on Women's Sex-Based Rights. This can be accomplished with any existing or proposed law, regulation, or court ruling in any country. I would encourage lawmakers and policies everywhere to engage in this type of analysis. Thank you so much for having me here today. One is I really appreciate Laura's presentation and description of social cascading. And the reason I've been thinking about this is that people often ask me, why has the United States federal judiciary caved so much to the gender identity industry? Many of us can understand why our elected officials might cave, because they have to raise money and they get a tremendous amount of money from the gender identity industry. And so they're to a certain extent at their bidding. But United States federal judges have lifetime appointments and are less vulnerable. And so people ask me, why is the United States judiciary caving so much? And my very unsatisfying answer to that question is I do not know. And so Laura, thank you for your presentation on social cascading, because that's given me some insight into why this is happening. And the other thing I just wanted to say is that it's a bit difficult here for us in the US because of course the United States has not ratified Cedaw. And so the declaration clearly is very heavily grounded in Cedaw. However, I don't think that matters, because even if the declaration were not grounded in Cedaw, its principles still stand. Its principles are fantastic and wonderful for protecting women's sex-based rights. And so we at the US chapter of the Women's Human Rights Campaign are very enthusiastic about using the declaration and promoting it and talking specifically about how laws that are existing and laws that are being proposed are or are not compatible with the declaration, regardless of whether the US ever gets around to passing Cedaw, to ratifying Cedaw. Thank you.